emanating from Article 63(1) are governed by international law. This includes their scope, characteristics, and beneficiaries. Therefore, a judgment of the court must be interpreted as imposing international legal obligations, with compliance with these obligations not being subject to modification or suspension by the respondent state via the invocation of provisions of domestic law. Also, the case law of the court has established that is a principle of international law that all violations of international obligations that result in damages create a duty to provide adequate reparations. In general, the basic purpose of the measures of reparation is to provide victims and their relatives with the restitutio in integrum of the damage caused. Reparations are divided into measures of satisfaction and indemnity in the sense the tribunal has considered three elements in establishing measures of satisfaction: justice, the non-repetition of the facts, and public recognition of responsibility. The three elements, both individually and combined, contribute to states the full reparation of the violation of the international obligations. In addition to measures of satisfaction, pecuniary indemnities are required of states that have committed a violation of their international obligations and obligations under the Convention. The main purpose of indemnities is to repair the damages, both pecuniary and non-pecuniary damages, suffered by the injured parties. The evaluation of the damages are injuries suffered, and injuries suffered must be proportional to the graveness of the violation of the damage caused. The court also found that in addition to just compensation, indemnities must include the reimbursement of the costs and expenses that the victims, their relatives, or the representatives have to incur and that result from representation in proceedings before the domestic court and also in international bodies. In general terms, we can say that a judgment seeks reparation, the restitution of the right that has been violated, and indemnity, satisfaction, the rehabilitation of the victims, and measures of non-repetition. The judgment is in and itself a form of redress. With regard to pecuniary reparations, in the majority of the adversarial case that it has heard, the court has ordered the payment of just compensation to provide reparations for the consequences of the damages of loss suffered due to the violation of a right or liberty protected by the American Convention. As the Inter-American Court has established in its settled case law, Article 63(1) of the Convention contains customary international law constituting one of the fundamental principles of contemporary international law on state responsibility. When an unlawful fact arises that is attributable to the state, that is international responsible for violating an international law, with the subsequent duty to provide reparations and to cease the consequences of the violation. in applying this law. The Inter-American Court has been exhaustive in the examination and determination of measures guaranteeing the rights violated and in the reparation of the consequences of those reparations. These measures have generally included the payment of an indemnity for the damage caused, but are not limited to this. The court's reparation regime is characterized by a holistic rather than a wealth-focused perspective. The inclusion of reparations of positive and non-pecuniary character that seek to ensure, among other things, rehabilitation and satisfaction of the victim as well, and the non-repetition of the detrimental facts illustrated this. Nevertheless, the importance of compensatory indemnity in the reparations regime developed by the Inter-American Court is undeniable. Effectively, this measure constitutes the most frequent of reparations in the case of the tribunal, and in the turn has the highest rates of high and prompt compliance. In this, the practice of the Inter-American Tribunal is not different from other domestic law or from the repertory regime of international law in general, in which reparation of the damages is in financial terms, clearly constitutes a typical measure of reparation. In the case of international human rights law, the compensatory indemnity is based on various universal and regional international instruments. Given the nature of the rights violated in the examined up to the present day by the Inter-American Court, in keeping with the contentious jurisdiction, most of them the right to life, liberty, and humane treatment, as well as the growing number of victims involved in the case, the reparation of damages in financial terms has turned out to be a complex task. Now, allow me to say a few words regarding a very important subject within this matter. What is other forms of reparation? When addressing situations that have comprised the violation of human rights and in seeking measures to redress the damages caused, the court has innovated in this case law. Given that restitution integrum is not possible in all cases, in keeping up with the principles of international law, the tribunal has ordered states responsible to pay compensation, indemnities, and reimburse costs and expenses, as well as to adopt non-pecuniary measures toward reposition of restoring the rights violated and providing rehabilitation and satisfaction to the victim. This last measure includes the carrying out of acts or works with a public scope of impact, such as the broadcasting of an official message repudiating the violations of human rights at issue and expressing commitment to the efforts toward ensuring that the violation do not occur again, and having the effect, among other, of recognizing the dignity of the victims. In this sense, the court has ordered the following among other forms of reparation: carried out housing programs, medical and psychological treatment, establishing the whereabouts of the victim, and, when appropriate, searching for the victim's remains and turning those remains over the victim's relatives, publishing the pertinent parts of the judgment public acts of acknowledgement of responsibility and redress to the victims, monuments, educational measures, demarcation of land, investment in community projects, adjustment of prison conditions, classification of crimes, development funds, and domestic legal measures. Now let me say in conclusion, I'm sorry about my voice. It's not helping me today. In conclusion, allow me to say that without any doubt, the Inter-American Court has developed its case law on the issue of reparations and provisional measures more than the European Tribunal of Human Rights. This is an area in which, given the subject matter of the cases coming before the Inter-American Court these days, we are in the process of an accelerated development in which, year after year, new subjects are covered on the issues of reparations, especially in areas like due process, access to justice, the right property, and amnesty, among others. Thank you very much. Have a good day.
Thank you very much, Judge Ventura Robles. As Manuel said, conferences which I've attended with the judges of the European Court, they've always spoken with great admiration about our orders of reparation. And I suspect they're quite envious of us, that we can be so creative in our orders. Our next speaker is the Honorable Justice Winston Anderson, who is presently a judge of the Caribbean Court of Justice. He was formerly professor of private international law in the Faculty of Law, and here, I believe, and legal counsel of the Caribbean Court of Justice. His areas when he taught were environmental law, private international law, and insurance law. I'm sure Justice Anderson is going to titillate our senses now. Please welcome him to the podium. Thank you.
Thank you, Madam Chairman. And please allow me to adopt the protocol established earlier and recognize Your Excellencies, Your Honors, distinguished ladies and gentlemen, students. I am in a slightly better position than the Chief Justice, who did not have a paper. I do in fact have a paper, but that paper was delivered to me this morning by my daughter. So I was busily reading it before I got up. Please permit me to begin by welcoming as both timely and crucially important this examination of the relationship between the Inter-American System of Human Rights and the Commonwealth Caribbean. I believe that this relationship has both present and profound implications for the advancement of human rights in the Caribbean and also for the definition of the Caribbean legal identity. There is no doubt that the Inter-American System has been a catalyst for significant progress in the protection of human rights in the English-speaking Caribbean. a whole cadre of human rights groups has emerged. Judges have drawn upon inter-American human rights law to strike down the mandatory death penalty. The executive has been obliged to await the receipt of the reports of human rights bodies before carrying out judicial sentences of death, and the legislature has been curtailed in the enactment of laws that could infringe the right to life. There are good reasons to believe that there will be similar developments in relation to other human rights, perhaps most imminent, rights associated with sexual orientation. On the other hand, it is equally clear that there is a real disinclination on the part of Caribbean states to accept leading instruments and institutions of the Inter-American system. For example, whereas all 12 Commonwealth Caribbean states are members of the OAS and thus accept the competence of the Inter-American Commission to make non-binding reports and recommendations concerning their observance of human rights, only 4 of these 12 states have ratified the important Inter-American Convention on Human Rights: Grenada, Jamaica, Barbados, and Dominica. Of these 4, only Barbados has taken the further step of accepting the jurisdiction of the Inter-American Court of Human Rights to make legally binding decisions in respect of provisions of the Inter-American Convention. Trinidad and Tobago, which in 1991 had accepted both the convention and the jurisdiction of the court, took the unprecedented step of withdrawing its ratification in 1998. I think it is entirely appropriate that the reasons for this reluctance to join, and indeed regret at joining critical institutions of the Inter-American system, are interrogated and critiqued here at the Cable campus of the University of the West Indies Faculty of Law. In addition to the license of academic freedom, these hollowed walls provide the illumination of a rich heritage of relevant Caribbean jurisprudence. The torch was lit by the founding fathers of this faculty, particularly Ralph Carnegie, who taught constitutional law to the first generations of Caribbean law students. It was carried by the early pioneers, Francis Alexis, who authored a book on the subject, and Margaret de Maurier, who introduced Caribbean human rights into the UWI syllabus. The torch has been carried in more recent times by Hugh Rawlins and Tracy